Good evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Well, it is Tuesday night, ladies and gentlemen, and we haven't done a Tuesday night live in a couple of weeks just because of some scheduling issues, things had to take care of, and unfortunately I have to take care of those. But it is Tuesday, June 10th. Can you believe we are already 6 months into this year? Man, it goes by so fast, doesn't it? Well, we have a great show for you today. I hope you were able to check out the show that we did today. I think it was a good show. Always try to put out a good product for everybody. I was looking at a couple of things before we started, because we've been doing this for a while now, and I couldn't believe it. We are over 70 million views here on Crime Talk since we started. We're almost to 300,000 subscribers, 296,291 as of right before going on the show. And our Facebook page, we're almost at 500,000. We're at 459,590. So, always get impressed with those numbers, not about me, but about you all for sticking with us. I think we've been doing this going on 6 years now. And I know there's people out there with more numbers and things like that, but it's basically their full-time job. This is my a few hour a day gig, so to speak, to hopefully keep people informed about cases, explain things about the law and the cases. And, since... well, frankly, I hate to go too far, but I think I've got more experience as a criminal defense attorney than just about anybody else out there. Because I try cases. And it's not like, one a year. I mean, and I've won 2 of my last 3 since, well, I guess the first of the year, to be honest with you. So, and the one that we lost, it was a, one with inappropriate pictures with kids. Tough cases to win. And what can you do when clients don't want to take your advice? You go take the trial. You go do the trial, and you do everything you can to do it and zealously represent them. So yeah, like I said, we try cases. It's funny. I heard there was a little brouhaha about somebody out there. He's saying he tried 100 murder cases. I'm like, interesting. Well, I can tell you, I've got 4 on my current calendar, and we just picked up another attempted murder today. So, like I said, like to think we know what I'm doing. I'm not saying I get predictions right all the time, but I think I've been incorrect less than I've been correct. Let's just leave it at that. And hey, it's like anything in life, right? Particularly as you're an attorney. Sometimes I just don't get it. People are like, I have picked a side regardless of the evidence. I will never believe what the other side says. They're obviously cheating. They're lying. They're not playing fair. You know what, ladies and gentlemen? Welcome to litigation. Welcome to litigation. I was looking at something on X the other day, and somebody said something like, I can't believe that the prosecution is trying to keep out the defense witness in the Kohberger case, or in the Karen Reed case. And I can't believe they're trying to do that. And my response was, the defense has done the same thing to the prosecution. The prosecution's done the same thing to the defense. It's called lawyering, ladies and gentlemen. Just because you don't like what the other side is doing doesn't mean that they're cheating, right? You got the rules, and the judge decides whether somebody's cheating or not. And if the judge gets it wrong and there's a conviction, then it goes up on appeal. But that's just lawyering. I think it's funny how so many people that don't follow necessarily all of these, true crime cases that people get interested in, and all of a sudden they watch a trial and they're outraged at the prosecutor is being sneaky and slimy. Well, most of them do that, particularly if they think they're losing. Okay. And oftentimes they just got better facts. Let's face it. The law, people are outraged that, I support a defendant and I cannot believe that this is going on in a courtroom. Well, clearly you don't pay enough attention to what's going on in the court system, ladies and gentlemen. It is completely stacked against the defendant. First of all, think about it. If it's in a state or a commonwealth, it's all the resources that come with that versus the defendant. They get the resources of the state, right? The prosecutor, the police, all the associated agencies that go with it. And it's your little defendant. And then maybe they get an attorney. If they can't afford one and they qualify, like they're in custody, they get a public defender. Some of the best public defenders some of the best trial attorneys I've ever seen have been public defenders. And I mean that. You always hear, oh, somebody was a public pretender, blah, blah, blah. No. Some of the worst attorneys I've ever seen have been private counsel. Some of the best attorneys I've ever seen have been public defenders. So when people say that, oh, I played a public pretender, I could have beat the case. No, probably not. And I doubt it. So it just drives me nuts. Anyway, we digress on that. But some people are like, dude, the entire system is not, I wouldn't say rigged, but it's stacked against the defendant, right? People are upset. I can't believe the judge did this. You almost have to expect when you go in as a criminal defendant. So if you're on the defense side, right, you need to realize you're probably going to get your motions denied. You're probably going to get your objections overruled. I have literally won trials. I remember I had a homicide case years ago. It was down in Arapahoe County. And the client, I'm going there and I'm talking to him. He's like, man, I don't know if I need to get myself a new attorney. I said, what's your problem? Are you unhappy? What's going on? He goes, man, you've lost every motion that we filed. And I'm like, yeah. And, I kind of told you we would. And, the facts, the law is not really on our side. And frankly, this is a question of fact for the jury to decide. Did you kill the person? And he's like, well, I don't know, man. I'm a little nervous. We've lost every motion. About halfway through the trial, same kind of conversation. Man, she is overruling all your objections, this and that and everything else. I get it, man. But as you can see, I'm fighting for you. I'm doing everything I can for you. And, then it came down like, I gotta, should I testify? I was like, dude, don't testify. We got reasonable doubt. Gave my normal. I literally have won more cases when you do not present any evidence and you just argue that there's not reasonable doubt. There's reasonable doubt that the government has failed to prove their case beyond a reasonable doubt based upon the evidence that they presented. One more case is that way. The one I just did in end of March, part of April. Rested, not guilty. Just does the defense want to present a case in chief? No, Your Honor, we rest. Not guilty. All counts. And that was a case where they had wiretaps against my client, ladies and gentlemen. A co-defendant came in and testified against my client. What possibly am I going to put up, right? You can see that. And when, all the planets align, if you think about like the Karen Reed trial, first time through, all the planets aligned. And I would have said in the first trial, not guilty. The prosecution screwed it up. They raised some doubt, and they probably should have won. And then when it came to, asking for the verdict, the attorneys all screwed it up. Should have asked, well, let's take a verdict on the counts that they present. But unfortunately, the jury didn't say we've reached a verdict on 2 counts and not on the first. Now, as time has gone on, and I've watched the Karen Reed case, and we'll talk about this in greater detail and then we'll talk about, but I want to talk about the Kohberger case because there's some breaking news there. This Brennan guy, whether you like him or not, seriously, ladies and gentlemen, he didn't have a great day today, but this guy's good. Okay. This guy is good. And he's a defense attorney. You can tell he's a defense attorney because he likes to lead. He likes to lead questions, and sometimes he gets shut down on that. And whether you like him or not, you say, I've seen people, he's he's dirty, rotten. He's a prosecutor. He was a prosecutor before he became a defense attorney. And he's been hired. He's a hired gun, ladies and gentlemen. Just deal with that fact. And they hired him because he's good. And I'm telling you, I know there's some people, he has a reasonable doubt. No, he's done what he needs to do. He's an experienced prosecutor and defense attorney, a hired gun as a prosecutor. And he has gone in there. And I'm telling you, he has gotten more stuff from the defense witnesses than Even some of the prosecution witnesses, they got better stuff for the prosecution than the defense has from the defense witnesses. The man is good on cross-examination. He prepares. He clearly uses the chapter method taught by Larry Posner, probably one of the greatest defense attorneys of all time ever. And, he's doing a great job. Let's face it. You may not like it, but he is. And, the case didn't get thrown out at halftime. It's certainly not going to get thrown out when the defense finally rests, hopefully tomorrow or so. And then they're going to renew their motion for judgment of acquittal, saying, Judge, I understand up to that point, but now that, we've presented evidence, we move for a motion for judgment of acquittal. And that will probably be denied because the legal standard is such that the judge should not become the 13th juror and, impose her will basically on the jury whatsoever. It's a question of fact. I don't know what the jury's going to believe. Now, if I was a betting man, I'd say they'd probably convinced at this point that, O'Keefe got hit by the car. We got a lot of data that says the car went back. His phone data said it basically stopped. And although this doctor today, what was her name? Lapalooza or something? I don't know. That's not right. I got my trial notes here. La Posada, that was her name. La Posada. Well, I didn't look at anything related to the car accident because it's obviously not a car accident. And I love it. Hey, Dr. La Posada, have you seen this video? Let's play this video. Oh, no, I didn't get to see that video. Now, there was some objection after that, but the point is she didn't even consider it, even though a lot of her testimony was, you have to consider everything. So, the bottom line is it is what it is. I don't know what's going to happen. The defense, like I said, they seemed a little slow getting started. It clearly has not gone the way that they wanted. Remember all the people? He was assaulted inside the house. It's a conspiracy by the police. I hate to say it, ladies and gentlemen. Zip, zilch, nada. That will not be argued at the closing. The only thing that's going to be able to be argued is the prosecution did a terrible job investigating this case, from the police that first arrived to the detective that you're going to hear that, he sent some unprofessional emails, ladies and gentlemen, or text messages to a group of friends. I don't know about you, but what's the word I'm looking for? Has anybody ever received anything in a group chat with friends that is inappropriate? Now, I never have, of course, and I have no idea what anybody's talking about in that regard. But the point of the matter is, really, if that's all you've got, because he used some words that rhyme with punt, completely inappropriate. And if my mother was still alive, she would smack my mouth for ever using that word, because she said you never, ever use that word. But the reality of it is, ladies and gentlemen, that is not necessarily a conspiracy. So the conspiracy thing in the Karen Reed case is gone. Gone. The best they're going to be able to argue is obviously a reasonable doubt, terrible investigation, and we have people that say there was no car accident. And they're going to say, look and use your common sense, ladies and gentlemen. He didn't trip and fall and stumble. We've recreated what we believe to be the accident. And oh, by the way, so did the defense expert. And frankly, they did a better job recreating it than the prosecution witness did. So let's go ahead and play that for the jury. And oh, by the way, here's her statements, Miss Karen Reed's statements, where she said, oh my God, did I hit him? I didn't think that I mortally wounded him. Her own statements coming back to bite her in the butt. And I still think probably one of the greatest questions that the defense, although they don't have to prove anything, but I think a juror could say, and I think the prosecution can argue it, why, if John had gone into the house, was she worried about hitting him or thinking that she hit him, because he was clearly gone? So I don't know. Listen, and this is what sometimes amazes me about criminal cases, right? This thing happened, January 29th, 2022, all within a matter of seconds. And we have now spent, second time around, we're on day 30. Tomorrow will be day 31 of the Karen Reed trial. Okay. Talking about these 29 seconds, right? Or whatever the total amount is. I mean, it's like a little bit of overthinking there, I guess. But the reality of it is that's a trial, right? Every defendant has a right to make the prosecution prove their case beyond a reasonable doubt. The defense can poke holes in it, try to raise that reasonable doubt. And if they can find experts to say, yep, I don't think that's an injury from a car accident. I think that's injury from a, dog bite. And he hit his head, right? And it could have been on the rocks near the flagpole that was right there. And when he got, you get differing opinions. Reasonable people can disagree. Sometimes you get experts to say, I can't testify for it because I totally agree with the other side. So, those are just some things that juries have to decide. Like I said, think about it if it's a civil case, ladies and gentlemen. Not did you murder somebody or you admitted you murdered somebody and it was self-defense, right? Jury decides whether it's self-defense or not. Just like a civil case. You got competing views. One witness says the guy going this way had the green light. The other person on the other side of the street said, no. This guy had the green light. And they hit in the middle of the intersection. And the jury wasn't there. They have no idea. But they know that they have this accident that took place. And the question is, who's responsible for the accident? That's a question of fact. This is really just a simple traffic accident, but there was a death involved. So they obviously jacked it up to a felony because there's allegations. And by her own admission, she had been drinking that evening. In her statements of, I'm not a very good criminal. I go home when I do. Go home and drink, sleep it off, and then drive back. Yeah, that's pretty much what the prosecution is saying. How would you been a better criminal at it? Jump out of the car and say, oh my God, I accidentally hit him. I didn't see him there. Oh my goodness. I mean, seriously, that's what it was. And listen, I've done lots of hit and runs and failure to leave the scene of the accidents over the years. I've had some literally where we were able to run the statute of limitations out on things because people kept their mouths shut. And I don't know what it is, but normally it involves alcohol. When somebody gets involved in an accident, they flee. I've represented little old ladies that did nothing wrong, but they freak out and they flee the scene. And it's like, why did you leave? It would have been no big deal. Just give your information. You had plenty of insurance. Everything's in order. You never had a ticket in your life. Why are you? Well, I don't know. I just freaked out. I got scared. People panic in those types of situations, particularly if they think they've injured somebody, for goodness sakes. So I don't know. It's been an interesting day. Obviously, we heard La Posada testify, and we heard the other, and her testimony was limited, to say the least. And so it's going to be interesting to see how things go. The big second ARCA witness will be testifying in the Karen Reed case here shortly. Or I actually got on the stand today. They're going through all the prerequisites. How smart are you? Tell me what your qualifications are. What you do for a living. Have you ever taught? Do you keep up on new developments in your area of expertise? Have you ever published any articles? Blah, 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 blah. Oh my God, my expert's smarter than your expert. Who are we going to believe? Right? I mean, in all honesty, you don't have to have a college degree to be an expert, ladies and gentlemen. You don't. But for some reason, those are always the ones that wind up in a courtroom testifying, saying, no, I'm right. And these engineers, we had this case once. It was a gun manufacturer case, criminal case, where literally we created this great montage. And I wish I could play it because I took Frank to trial with us. It was during COVID, and literally this montage of all the body cam videos, everything It just went off. It just went off. It just went off. And this particular firearm had some not negligence, spontaneous discharge, so to speak. And that was our defense. And we had this guy, expert come in, and he's like, this particular firearm has had issues. And I mean, I remember we flew down, we picked him up, we flew him up, we put this gun in like a big old X-ray machine. What's the one? MRI machine, literally an MRI machine, to make sure, see if all the little springs and everything were attached. Like, okay, all right, no. Had a working theory that the gun was going to go off, and these guys they did tests, they tried to recreate it. And sometimes sometimes you just can't recreate it exactly. It's just the way it is. Like when your car doesn't work and you take it in, it's making this ticking sound, and then you go in and there is no ticking sound, and everybody thinks that you're an idiot and you're hearing things, and you're like, no, I swear there's a ticking sound, right? And then you drive off and the ticking sound begins again, right? Those are the kinds of things. Sometimes they can't recreate those types of things. And it's kind of like accidents. I mean, I've seen people in horrific accidents where other people die and other people walk away without a scratch on their arm, not a bruise, not a broken bone, nothing. And you're just like, how did you survive this? I don't know. And so I don't think it's necessarily completely implausible that O'Keefe can get hit. And he should have had a broken bone. Well, says who? Says who? I've seen people, accidents, right, where people parachute doesn't open, and they, dead cat it and kind of hit the ground twice or whatever, and they live. You think, oh my God, they should have a broken back, but they don't. They get up and walk away. Crazy stuff like that happens, ladies and gentlemen. And because you can't necessarily recreate exactly how it's done, doesn't mean that it didn't happen. I mean, you can do your best, but you got a bunch of drunk people late at night, in the dark, in the cold, still drinking, somebody backing up, and according to the data, 27, 29 miles an hour, excuse me. And then within minutes, seconds, the phone goes dead. I mean, what do you do? Stumble around, walk inside, get his ass kicked, then come outside and do that? I mean, it's just not possible. And there's been no evidence presented to it as it relates to this particular, this particular trial. I mean, like I said, all the planets aligned in the first trial. And I told you, go back and look how many times I've been saying it right after this trial. This is not a good thing. I said, this is not a good thing for Karen Read, because the prosecution fixes their case. They realize what they screwed up the first time, and then they fix it. What did they do here? They fixed all their problems. What did they try to do? Oh, we're going to exclude this witness for this. We're going to limit the testimony on this. We're not going to call this witness because they're bad. Who else could we use to get all that same information in? There's nothing that says you have to call everybody who works on the case. You may have to deal with it. It may not be able to help you meet your burden, but at the end of the day, it's still the evidence. So, like I said, I don't know what's going to happen. I mean, like I said, if I was a betting man, I think I'd tell, Karen Read to, get maybe go watch a couple of the Orange is the New Black videos or something to that effect. I don't know what they're going to find her. I mean, who knows? They could be like, this is so obvious. She obviously didn't hit him. Why did this take 31 days, right? Or 32 days by the time we get there, depending on any case in rebuttal. I don't know. The judge keeps noting that they're getting bored. Okay. Which means I think it'll be a relatively quick verdict because they've had a lot of time to sit and think about it. And unless there's going to be some big discussion, it should be a relatively quick verdict. Quick verdict, I mean, days, maybe a day or two at the most. I've had trials that lasted for a day that go longer than that. But I've also experienced on long verdicts, long trials, you get quick verdicts because they've had a time to think about it, and their mind is kind of made up by this point. They're either getting it or they aren't. You know what I mean? So, all right. Let's talk about Bryan Kohberger. I got a little sidetracked on Karen Read. because it's easy to do. But it's a lot of breaking news. You're hearing it here first, ladies and gentlemen. New orders in the Bryan Kohberger matter. Now, of course, there's the order sealing the stipulation and order for admission of additional exhibits. Sealed. Order sealing the state's objection to defendant's offer of proof. Now, that's the one I want to see because that's the one related to the alternate suspect information. And then the order sealing defendant's motion and order for independent analysis of evidence. Ooh, apparently want to have an independent analysis of evidence at this point. What have we been doing for the last 2.5 years? Order sealing defendant's second amended phase 2 mitigation witness list. Order granting to exceed the page limit. Motion to seal defendant's second amended phase 2 mitigation witness list. And of course, we brought you this today that when I'm sorry, we have another order sealing order. Got to keep it simple. The sealed order, staying order dated June 9th is sealed pursuant to that. That's the one that we brought you today. And then you had the order that came out the other day, which was the order granting these to seal the records. There's so many orders. Let's see here. Where'd it go? Sorry. I lost my page here. But the one that is new, and like I said, the one today, as far as like, is there big news? I think somebody's filing in some sort of interlocutory appeal based upon one of these sealed orders. But of course, we don't know what it is. But the one that I want to bring you tonight is the state's opposition to defendant's motion to continue. As you may recall, the defense filed a motion to continue the jury trial, basically saying they're not prepared. It's going to deprive Bryan Kohberger of his effective assistance of counsel. And then bottom line, they just need more time and it's all constitutional. Death is different, etc. And as you know, if you've been here for a while, I like to just read the motions. I can summarize them. I can paraphrase them. And if it gets too much, I can do that as well. But in this particular moment, sometimes the wording in you gotta appreciate the tone. Okay. So here's the people's opposition to the defendant's motion to continue. Comes now the state of Idaho by and through the Latah County prosecuting attorney and submit the following opposition to defendant's motion to continue. Parenthetical, the motion. Introduction. It is time to try this case. Defendant was arrested in late December of 2022 and was indicted in May of 2023. He successfully moved to transfer venue to Ada County, and in October of 2024, this court entered its scheduling order setting deadlines for pretrial motions and expert disclosures. Defendant complied with those deadlines without moving for a continuance, including by disclosing 6 expert reports for the penalty phase, disclosing over 2,100 pages of purported mitigation materials, listing 55 penalty phase witnesses, and identifying 132 exhibits he may introduce during the penalty phase of trial. But now, after all discovery deadlines have passed and after the court conducted the pretrial conference, defendant seeks a trial continuance of unspecified length. He bases his request on his claim that his mitigation investigation is incomplete. While the state is unable to see whether defendant's ex parte filing to the court contains specifics, his motion does not. Defendant has not shared what new evidentiary material he seeks to obtain or how additional investigation will actually produce them. Overall, the record before the court shows that the defendant's investigation has already plowed the necessary ground. Now, while defendant is fully entitled to due process, this court should exercise its broad discretion to deny defendant's 11th hour motion. First, the defendant cannot show good cause or prejudice. Even under the heightened, non-binding ABA standards he seeks to impose on this court, his counsel's resources and investigation to date have been adequate, even setting aside that the defense team still has more time to prepare its mitigation case. Moreover, Idaho's Constitution also grants the victims the right to a timely disposition of this case. The court should give these victims' rights substantial weight in considering the motion. Finally, while the publicity surrounding this trial is a challenge, defendant has not shown and cannot show that continuing the trial will make things any easier. It is just as likely that delay will make it harder to seat a jury. For all of these reasons, the court should deny the defendant's motion. Then let's go into the procedural background. The defendant was appointed his lead counsel in December of 2022. In March of 2023, a second attorney was appointed to represent him. Then in February of this year, a third attorney was appointed to the defense team. The first district public defender has also been participating in the defense. And in addition to his lawyers and their staff, defendant has 2 experienced investigators and a mitigation specialist working on his behalf. In January of 2024, the defendant moved for a change of venue from Latah County due to the publicity surrounding the case the size of Latah County. His motion was granted and the case was moved to Ada County. And then on October 9th of 2024, this court issued the operative scheduling order that contained deadlines for motions, expert disclosures, and pretrial filings. More recently, at a pretrial motions hearing on April 9th of 2025, the court advised defendant's counsel to ask for more resources if the defense team needed assistance reviewing the discovery. The state does not know if this occurred. Throughout this case, the defendant has been able to comply with the deadlines in the scheduling order. Pertinent to the instant motion, the defendant has, on January 23rd, 2025, made his guilt phase expert disclosures consisting of reports from 16 experts, including a psychologist who conducted a mental health examination of the defendant, Dr. Orr, and a forensic psychiatrist who researched his life history, Dr. Ryan. On March 3rd of 2025, supplemented his guilt phase expert disclosures with reports from 2 additional experts. And as of June of 2025, had disclosed in discovery over 2,500 photos and videos, over 3,500 pages of investigative materials, and many megabytes of electronic data related to the guilt phase. On March 31st, 2025, made his penalty phase expert disclosures consisting of amended reports from Dr. Orr and Dr. Ryan, respectively, plus reports from 4 additional experts, 3 of whom are behavioral health neurology professionals, and as of June of 2025, had disclosed approximately 2,100 pages of purported mitigation materials and identified 55 defense witnesses and 132 defense exhibits for potential use during the penalty phase in this case. The defendant also opposed the state's motion for examination of defendant pursuant to Idaho Code Section 18207 and for an extension of time to complete rebuttal penalty phase expert disclosures, argued May 5th of 2025. At that time, the defendant did not preview for the state or the court that he would seek a trial continuance, and the court denied the state's request for personality testing by its experts, in part because the pending trial date conflicted with the time that would be necessary to explore that issue. Then they give the legal basis. Trial judges necessarily require a great deal of latitude in scheduling trials. Accordingly, the decision to grant or deny a motion for continuance rests with the sound discretion of the trial court. And when reviewing the trial court's decision for an abuse of discretion, Idaho Appellate Court analyzes whether the trial court, 1, correctly perceived the issue 1 of its discretion, acted within the outer boundaries of its discretion, acted consistently with the legal standards applicable to the specific choice available to it, and reached its decision by exercise of reason. The United States Supreme Court held that the denial of a motion for a continuance is grounds for relief only where the trial court's action is so arbitrary as to violate due process. Similarly, under Idaho law, unless an appellate shows that his or her substantial rights have been prejudiced by reason of a denial of his or her motion for a continuance, appellate courts can only conclude that there was no abuse of discretion. The bare claim that additional investigation could have conducted is not sufficient to demonstrate unfair prejudice so as to support filing a motion for a continuance. In exercising their discretion, trial courts are also guided by the Victims' Rights Amendment to the Idaho Constitution, specifically Article 1, Section 22, and the Idaho Code Section 19-5306. Both provisions entitle victims to a timely disposition of the case. Section 19.550. Let me start that one over again. Section 19-5306, subparagraph 3, expressly provides that the right shall apply equally to the immediate families of homicide victims. Argument. The defendant couches his defendant couches his motion in terms of his constitutional right to due process, to effective assistance of counsel, to an individualized sentencing determination, and to a fair trial in light of the intense media coverage. But he has not demonstrated that these rights, which must be evaluated alongside the victim's rights and the overall administration of justice, will be violated if this case proceeds as currently scheduled. For the reasons discussed below, the court should deny the motion. The court should deny the defendant's motion because he cannot show good cause or potential prejudice. Procedurally, he does not explain why he waited to seek a continuance until after discovery closed, expert disclosure deadlines passed, and the pretrial conference happened. Substantively, he ignored Idaho Supreme Court death penalty precedent, holding that counsel is not required to investigate a defendant's entire life before he can be tried or sentenced. He neither specifies additional areas for investigative nor explains what concrete investigative steps will bear near fruit at either the guilt phase or the penalty phase. As such, defendant's motion amounts to a request for a perpetual continuance so that his counsel can go down every rabbit hole until defendant, rather than the court, deems himself ready for trial. The law requires no such thing. The court should deny the motion because the defendant's team has had the opportunity to prepare and adequately address the issues he claimed needed more attention. The scheduling order granted the parties ample time for trial preparation, and it also set several interim deadlines along the way, including for the penalty phase experts to disclose and disclosures and mitigation disclosures, which is the primary basis for the defendant's motion. The state also understands that the court set the pretrial conference more than 2 months before trial in order to give the parties sufficient time to prepare for trial after discovery closed and all pretrial disclosures and motions practice were complete. If defendant was having trouble meeting deadlines, finding experts, or pursuing red flags, he should have sought a discovery extension or trial continuance long before now. He did not do so. Instead, defendant retained over a dozen guilt phase experts, 6 penalty phase experts, a mitigation specialist, and has identified over 2,100 pages of purported mitigation material. And leading up to the pretrial conference, he exchanged witness lists and exhibit lists with the state without stating that he'd be moving for a continuance. While the defendant relies on death is different mantra and argues that extraordinary measures must be taken to protect his rights, he cites no authority for the proposition that reasonable scheduling orders should not be enforced in death penalty cases. Indeed, defendant recently argued that the state improperly delayed in seeking an extension of time for its rebuttal phase experts. And the same principle should apply to him. Defendant's motion is untimely and weighs in favor of its rejection. The defendant bases his motion on a claim of insufficient resources and need to conduct more investigation prior to trial, but he has not demonstrated that he is being deprived of anything that he seeks. Thus, defendant claims about the current state of the defense team's preparation are matters of speculation and are not the type demonstrable reality needed to support a continuance based upon the defendant's constitutional rights. Defendant has 3 trial attorneys, including a lead attorney who has represented him from day one, 2 investigators, and the assistance of at least 1 additional public defense attorney. He has also engaged an outside mitigation specialist to assist in obtaining materials for use during the penalty phase. This record reflects that this defense team has been working hard for defendant and, as explained below, has met the professional standards for the defense of a death penalty case. Yet defendant still claims this court is cutting off his review of discovery. This is unfounded. Defendant's attorneys have had sufficient time to review discovery and have not established by any discovery violation by the state. They have been able to identify over 1,000 exhibits and nearly 200 witnesses for trial. Indeed, the court also recently admonished defense counsel to seek additional resources from the resource judge if they needed more assistance to review discovery and prepare for trial. The defendant has not claimed that he sought more resources and was denied. Neither the size of the legal team nor the need to continue the review of discovery forms a valid basis for the continuance. The defendant has been able to retain a large number of experts, including 6 experts focused on mitigation for the penalty phase. 5 of these experts are mental health professionals. Both a psychologist and a forensic psychiatrist have examined the defendant on multiple occasions, reviewed his social and medical history, and diagnosed him with autism, OCD, ADHD. Collectively, these experts took a deep dive into the defendant's entire life, including by interviewing his family, teachers, coworkers, and even psychologists who evaluated defendant as a child. The extensive investigation by these experts contradicts defendant's claim that he needs more time to complete a social history investigation. In this case, he cites counsel was ineffective for failing to explore mental health conditions or for failing to provide mental health experts with sufficient background information. In contrast, here, defendant's mental health experts have had access to a significant amount of people and material and have created fulsome histories through their own investigation. Defendants claim that his team needs to follow up on red flags is also unsubstantiated. In their report, neither his psychologist nor his forensic psychiatrist indicated they could not render opinions because of unexplored areas. In fact, the forensic psychiatrist concluded the defendant showed no signs of other serious psychotic disorders, and at a recent hearing, defendant represented that he would not seek to introduce evidence of the unexplored topic. Tellingly, the defendant did not seek an extension of the penalty phase expert disclosure deadlines. Defendant claims that more expert testimony is needed is speculative and does not identify what new information would be uncovered by further investigation. This is fatal to the defense motion. And then they go on, there's no authority to support defendant's desire for more time to conduct a scorch the earth life history investigation. Courts recognize that all cases, including death penalty cases, are constrained by time limits and resources. Let's see here. Faced with this authority, defendant turns to straw man arguments and non-binding guidelines to conjure up alleged prejudice. First, he cites cases where death sentences were overturned because lower courts failed to consider mitigation evidence. But there is no danger here. Starting the trial instead of allowing defendant to pursue a mitigation investigation with no end in sight does not amount to denying him the right to present a constitutionally adequate mitigation case. In any event, the current issue before the court is a request for continuance, not the admissibility of mitigation experts or the performance of counsel. The counsel's remains a matter of discretion. The court will be well within its discretion to bring this case to trial after 2 years and already robust defense investigation. Second, defendant relies upon the ABA guidelines for the appointment of performance of defense counsel in the death penalty case proceedings to list all the things that his counsel need to accomplish. This exercise is meritless as a matter of law and fact. As the law, the Idaho Supreme Court has declined the invitation to adopt these guidelines. And as a matter of fact, even the court looks to the ABA guidelines. The record reveals the defense counsel has complied with them. Table 1 and Table 2 attached to the brief cross-reference the list of tasks the defendant set forth in the ABA guidelines with the actual records in this case. The results show that the appellate court will be exceedingly hard-pressed to rely upon the ABA guidelines or any other basis to find the defendant has suffered prejudice if a trial proceeds as scheduled. It also shows that extending defendant's mitigation investigation will not serve as a useful purpose because at this point, any new information counsel hopes to find is based upon mere speculation. Now, defendant filed an ex parte, an additional document that purports to outline what new evidence he might seek and what strategies or tactics he might obtain in such evidence. Initially, the court expressed skepticism that the defendant's motion was properly filed ex parte and ordered the defendant to provide a redacted copy of his filings so the state to address its response. Defendant then objected to the order, and the state now understands that the court has decided not to require disclosure of the ex parte filing. While the state does not concede that the defendant has valid grounds for this objection, it will not address the objection given the court's decision. The state, however, does request that if the court has identified a basis in the ex parte filing to grant defendant's motion, that the court allow the state to respond to that particular issue. And regarding the ex parte filing, the court should deny the defendant's motion because of the resources he has at his disposal and the significant work already done to support his mitigation case. While defendant reasons for a continuance are unpersuasive, there is another reason to deny this motion. The victims in this case, including the immediate family members of the homicide victims, have a right under the Idaho Constitution to the timely disposition of this case. And given that it has been nearly 2.5 years since the defendant's arrest, the victims' rights and their desires for justice weigh in favor of proceeding to trial as scheduled. While the term timely disposition is not defined, it must mean that at some point, a trial court can decide that the administration of justice outweighs a defendant's desire to continue preparing his defense. That is one of the purposes of the Idaho Victims' Rights Amendment, is consistent with the Idaho cases requiring a defendant to show actual prejudice in order to successfully challenge a decision to deny a motion to continue. In his motion, defendant cites many cases where counsel failed to adequately prepare for trial or sentencing, but he cites no case where a court found that over 2 years was an inadequate amount of time to prepare, nor could he. He concedes that the Sixth Amendment only means the defendant is entitled to a reasonable period of time before trial, which counsel might prepare the defense. While he appears to want unlimited time, the defendant has already had a reasonable amount of time to prepare, as demonstrated by the substantial quantity of evidence his attorneys have amassed. Against this backdrop, the court can properly rely upon the victim's constitutional rights as a basis in the motion. There is no doubt that the publicity surrounding this case, including but not limited to a recent Dateline TV show containing non-public evidence, poses challenges for the court and both parties. The state reaffirms its commitment to comply with the court's non-dissemination order, to do everything in its power to prevent leaks and to assist determining which person or persons provided non-public information to Dateline. However, defendants' reliance on Dateline episode to support his motion is misplaced for several reasons. First, the question of whether the defendant can receive a fair trial is not answered by the amount of the nature of pretrial publicity. Rather, depends on whether a fair and impartial jury can be seated. As the United States Supreme Court had said, to hold that the mere existence of any preconceived notion as to the guilt of innocence of an accused without more is sufficient to rebut the presumption of prospective jurors' impartiality would be to establish an impossible standard. It is sufficient if the jury can lay aside his impression or opinion and render a verdict based upon the evidence presented in the court. Accordingly, the Idaho Supreme Court has long recognized that trial courts can successfully select an impartial jury despite widespread publicity. In State v. Federally, I'll keep out the sites, the death penalty case, the Idaho Supreme Court disagreed with the defendant's claim that extensive publicity prior to trial deprived him of the opportunity to be tried before an impartial jury. Because each juror was extensively questioned to determine the degree of their exposure to the pretrial publicity, defendants' rights were preserved. When the defendant later sought federal habeas corpus relief, the Ninth Circuit examined the voir dire process and found no prejudice, even though on day one of jury selection, the case was covered on the front page of the local newspaper, as well as the TV and radio. Here, the court's carefully crafted jury selection process has every chance to produce an impartial jury. Because of the sensitive nature of the court's voir dire procedures, the state will not address the mechanism of jury selection in this public filing. But suffice it to say, if an individual has been so impacted by the Dateline episode or any other publicity that they cannot be impartial, they will not be seated as a juror. Indeed, this case is not Ada County's judiciary's first experience with highly publicized trial in recent years. Like the court in the Vallow Daybell trial, this court is well equipped to select a jury, to handle ongoing media coverage, and to conduct a fair trial in Ada County. Second, the Idaho Supreme Court has rejected the defendant's theory that a continuance is necessary to allow media coverage to dissipate. There's no reason to think that the media coverage in this case will dissipate, so proceeding to trial as scheduled may actually avoid any negative consequences from future publicity. And defendants' dissipation cases occur in the 1960s and involve communities where it was presumed or demonstrated that residents had already formed an opinion based upon local media reports. Here, venue has already been moved, and the court will use a much larger pool of potential jurors in the defendant's cited case. This case is also proceeding in a highly fractured media landscape that bears little resemblance of what prevailed in the 1960s. What happened in the defendant's cited cases has no bearing on whether the court can select the sufficient number of impartial jurors in this case, and the court should deny defendant's motion because he has not shown that publicity surrounding this case will prevent a fair trial. There you go, ladies and gentlemen. The government's response to the motion to continue by the defense. I skipped over a lot of the citations. I think it is kind of this final footnote, though. In this light, it is relevant to consider how the specific jury pool at issue, which consists of citizens from Ada County, may or may not be impacted by media coverage. Local media is likely to continue to consistently report on the case regardless of the trial schedule. The November anniversary of the murder, for example, generates stories. And then the timeline 2 years after the University of Idaho murders, here where things stand, and they cite to the newspaper, and there's no basis to think that this dissipation is likely. I got to agree with the prosecution on that. Let's go try this thing. I think it was in the first line of their response, which was it's time to try this case. Boom, right there. It's time to try the case. It's time to try the case. You never have enough time to prepare for your homicide case. Litigation is a black hole. There's always something that can be done. There's always something that can be double checked, triple checked, always some witness you need to go re-interview. But the reality of it is, ladies and gentlemen, at some point, you got to stop looking for the document. You got to stop looking for that witness that doesn't exist, and you got to go try the case. I was told that by a very experienced criminal defense attorney who then went on to try very big civil cases, but he got his experience as a criminal defense attorney. And, and at some point, you got to stop looking for that smoking gun that's going to acquit your client. It's not there, right? Civil litigation. Why do I hate civil litigation so much? It's not about what the other side gave you in discovery. It's about what are they hiding from you. That's the way it is. And so, but at a certain point, you know what? You got to go try the case. You have to go try it. You can't sit there and wait forever for the perfect document to appear, for the perfect witness that's going to appear. At a certain point, you got to just go do it. And that's what the attorneys need to do in the Bryan Kohberger matter. 2.5 years, ladies and gentlemen, November of 2022. What do we need? 3 years? Why not make it 4? Why not make it 5? Will that give you enough time? My guess is even if you went out to the 5th year in this particular case, the defense would still say, let's go do it. And I understand what Ann Taylor's trying to do. She didn't miss any deadlines. She complies with the orders. She's trying to see if the prosecution breaks. They didn't. So now you got to go try the case. And unless you can really articulate, not just generalities of, Judge, I won't be effective. My client is charged with death and death is different. And I need to comply with the ABA standards, which I'm doing. I just need more time, Judge. I got to investigate, and the whole sealing that, that's the other motion I would love to see is the motion to seal. Where was it? Let me go back here. We got two that interest me. Defendant's motion in order for independent analysis of evidence. My first thought was, why are you waiting until this point? Motion to seal defendant's motion in order for independent analysis of evidence and good cause appearing. Therefore, they go ahead and they seal it. Okay. But then we have the order sealing the defendant's objection to defendant's offer of proof. Based upon the motion to seal, state's objection to defendant's offer of proof regarding alternate perpetrators and defendant's evidence in support of offer of proof regarding alternate perpetrators and attached exhibit filed, the court does hereby confirm an order that is exempt from the disclosure and sealed. So we got the defense offer of proof and evidence in support of the offer of proof for the alternate perpetrator, the state's objection to the defendant's offer of proof, and there we go. And then they got the other stuff, and we got the orders, sealing the orders. Then we got the motion offer of proof. Now, this was filed June 6th of this year, and the state filed their objection June 9th. So the prosecution has been on this indeed. Motion to seal the state's objection to the defendant's offer of proof regarding alternate perpetrators and defendant's evidence in support of the offer of proof. And of course, they filed at the same time. What did they file? The defendant's motion for independent analysis of evidence. Independent analysis. Why wouldn't they have their, I'm assuming the independent is the defense expert wants to look at it. They think there's somebody else that wants to look at it. I don't know. Normally independent analysis means the defense is going to do it. Yeah. Well, let me just look here. Caught my eye. So ABA standards are just suggestions. It's policy. ABA, is like in a perfect world when there is, no issues, limitations whatsoever. This is what should be done. And do not get me wrong. All right. Mitigation experts are important in particularly large cases like this. I can tell you, I just got one the other day. It was unbelievable. 2 mitigation people working on separate homicide cases. One, I got about 6 pages. Oh, here it is. Did you include the picture that we were going to told you to do? No, I figured you guys can add that later. Really, because that's kind of like your job to do that. Then another one for separate mitigation expert, 43 page that went through childhood trauma, all that type of good stuff. Amazing. So it just depends. So a question here. Somebody, let me, if I use the right computer here. Scott, what do you think the judge will do? I think it boils down to the whole issue, Jessica, as it relates to the third party suspect, alternate suspect. If the judge finds that there's some legitimate basis for that, the defense is going to get their continuance. If, on the other hand, I think the judge denies that motion, he's also going to deny the motion to continue. I understand it. I'm a defense attorney. There's some cases when they ask to set it, when would you like to set this? I don't know, 2045, please. 2045 would be good because all your witnesses will be gone. Maybe some will be dead. And maybe my client will have an opportunity to get a plea deal by that time because enough prosecutors will move through the office. They just don't care anymore. Okay. I get it. I've been there. But like I said, at some point, I'm a firm believer. Sometimes you just got to go try the thing. Go try it. That's how great attorneys win trials that they shouldn't have won in the first place is they just go and try it. I swear to God, this trial we did, what was it, March, April, whatever it was that we did? Everyone's like, why are you taking this case to trial? I'm like, man, the client wants to go to trial. Client wants to go to trial. It's too much time. Prove the case. Prove it. And they literally, I think they didn't believe me that we were going to go. And they thought that maybe I was going to show up on the morning of trial and grant a continuance. I like this judge. And this judge was like, we're going to trial. And, I kept out a lot of things. A lot of things sometimes the defense has is only the rules of evidence, right? That's why if you become a Patreon member, look what we give you. That's right. The rules of evidence, breakdown, and analysis of everything. You got to learn it, know it, live it, laminate it, Take it to the courtroom. Could save your life someday, ladies and gentlemen. Rules of evidence. That's what matters in a courtroom. It's not what you think. It's not what you believe. It only matters what you can prove with legal and competent evidence. So that's Jessica. I hope that answers your question. I think it's going to depend upon if the judge thinks there's a basis for this alternate suspect. And who knows? Like I said, we don't know. So there could be something. We'll have to wait and see. Scott, does the jury have to vote on all three charges in Karen and Reed case? Yes. Can only two of the three be guilty and one be not guilty? Well, it depends. I mean, they're separate elements, right? Or they have all separate elements. Second degree murder is basically that she intended to kill him. And I believe last time I was looking at that jury instruction there in Massachusetts, it was that knowingly or recklessly caused the death of an individual, right? Then she's got the manslaughter and then the vehicular assault, basically vehicular homicide. That's what we call it here. They think they call it something else. But basically you were drunk, you injured or killed somebody, kind of a strict liability offense, right? And so you've got that. So does the jury have to vote on all three? Yes, they will. And then the question becomes, well, what if the jury says, I want to find her guilty of everything? Well, they can, but then they've offenses merge into one another, because really they are basically, you got second degree murder, guess the elements would be different, but then you got the vehicular assault and then the reckless manslaughter, right? So the jury could do that, but they would all merge. But yeah, they could easily find her not guilty of all of the charges, guilty of some, not guilty of others, or guilty of all, and then let the attorneys sort it out. So yeah, hopefully that answers your question, Camilla. Time for change. Exactly. So the leaks coming from the prosecutorial office leaks should never be considered evidence, right? Yet here we are. If we're talking about the Kohberger, I don't believe there's been any indication that it's come from the prosecutor's office. In fact, it sounds like they're still investigating that particular issue. Let's see here. Is it Ian Howe? I don't care if I'm right or other people are right. Unfortunately, he died. His family is suffering, and the amount of social creating controversy just for views and clicks is sickening. Well, I can't necessarily disagree with that. I mean, the reality of it is, and here's the thing, ladies and gentlemen. I mean, if you're going to the courthouse and you're looking for justice, you're not always going to find it there. Okay? The law is not fair. And the reality of it is there's going to be a winner and there's going to be a loser. So, usually the people that win usually don't get exactly what they want. They're not. And they've had to go through the entire process. Now, hopefully you've never gone through, a criminal case or a civil case, but if you ever had to go through the process, it sucks. You're like, this is ridiculous. I can't believe I'm being, but you got to go through the process. And then sometimes you have to explain it's going to be a process, and we're going to do this. And then we're going to say this, and they're going to say, well, no, what about this? And ultimately come to an agreement, right? And if you can't, then you go to trial and you go and try the case. But people are not always happy when you get there. Any thoughts on the DOJ in the Karen Reed case? They looked at it. They're not going to charge anybody. They're not going to do it. They looked at it to see if there was some sort of grand conspiracy. They didn't find it. Let's see here. I don't know where I clicked on that one. Let me go back up here. I hope you used that site. Let's see here. Welcome, Jim. If Lori Vallow-Daybell is granted a new trial by the Supreme Court of Idaho, could the prosecution go for the death penalty? Thanks in advance. Unlikely, no. So if the trial gets reversed, unless they get acquitted of a count or two, they obviously can't bring those back. The other thing is normally if you go to trial, and you're retried, the sentence that is imposed cannot be greater the second time around than the first time. So, because it really doesn't matter in her case because it's life without parole, but they're not going to give her the death penalty. That's already been taken off the table. Let's see here. Nana Lane, I agree. I just want justice for John, but I don't think this is it. Kane Howe, you're absolutely right. Justice for John O'Keefe is being skipped over. Well, we talked about it early on. I mean, I really, I don't know. Like I said, I think it's going to be the orange is the new black by the time we get done. I don't think, and I'm not trying to be critical. Hey, they're doing what they're doing. I think this case has just gone on way too long. 31 days for a freaking hit and run. Swear to God, even this case in our jurisdiction, 4 days max, maybe 5. There's no way a judge would allow this. I mean, this judge, she's like Judge Ito judge. Well, come to the sidebar. Let's have another sidebar. No, you've ruled, right? You presented the evidence. An objection was made. You rule and you move on. You don't need a freaking sidebar for everything, or you do it right at the break. Christine wants to know, as Scott said about the KR case, if the prosecution case is weak, why put on a defense? I think the prosecution case is too good, and she is scared to go to trial without a better defense. Like I said, I don't think she's done anything that's particularly helped herself. You know, they got the new guy, the doctor on there, the biomechanical guy from ARCA. He was just getting started. But really, they've got to think, God, what does Brennan have up his sleeve today? I think he's made all their witnesses look, frankly, like idiots and got them to agree with just about everything. It took him a while and they fought him on everything, but ultimately he got them to agree. Bottom line, ladies and gentlemen. And that's just me. And like I said, I don't know any of these players. And I've said it, first trial, I would have said not guilty because I think the prosecution did such a terrible job. This time, just like in life, you make your decisions and you adjust based upon new information. They have tried a much better case. And if you try it based upon the evidence that has been presented, some of it by the defendant, I might add, that video where you've just explained their theory. Arm got hit, just like the trooper in the first trial said, and everybody laughed at him, mocked him. I may have even done so myself. And then, it turns out that it does make sense. And you think, oh, come on. How could you get hit like that and die? Well, if you're drunk and you're spun around at 29 miles an hour, right? And bam, you hit your head and you go to sleep. Just like the doctor explained today when they had the old cranial, the old noggin cracked open and looking at the old medulla oblongata in there, the old cortex down there in the the spine where it connects to the brain and all that stuff and the hemorrhaging. And I don't know if you guys have ever seen autopsy photos. I've always said, I've told everybody, if I'm dead, I'm dead. Okay. If it was quick, it was natural causes. If it was violent, you can figure it out. You don't have to do an autopsy on me, ladies and gentlemen. Autopsy is one of the most unpleasant things I think you can ever see. All right. I mean, they pop the top off, take the brain out, slice and dice everything, crack everything open. I can eat my lunch watching that stuff, but the reality of it is, do not do an autopsy on me. I don't need to know anything at that point. I'm gone. It's terrible. I get it. Even if justice needs to be done, still don't do an autopsy on me. It's just gross. They slice and dice it. And I get it. You're gone. Your being is gone wherever you believe that it goes. But you're just an empty vessel at that point. So why chop it up? Why chop it up? What was it? Who's this? Michelle Bundy filed for continuance, saying he didn't have time to write an opening statement. The judge said he could read his opening statement when the state rests its case, which is true. It was the sidewalk. She didn't hit him straight back. if he was on the sidewalk. Well, I don't think there really was a sidewalk there. It was kind of like a little curb thing, but I don't know. I mean, like I said, really the only people that matters, and we can talk about it till we're all blue in the face, but really at the end of the day, the only thing that matters is those 12 jurors that are ultimately the presumptive jury. Alternates don't care. We don't care what their opinion is. Yeah, it just really doesn't matter. So we'll have to wait and see. I think the prosecution's done a better job on that case. Kohberger, let's go try this thing. And I think we're going to talk about something else, but frankly, just didn't have enough time. You know why? Because we have to go do our Patreon show. That's right, for our Patreon members who fork out exorbitant money so they can hang out with us exclusively and access to a phone line where we can talk about whatever they want. Because why? It's their show. It's their Patreon member show. And I think you can join for $5, and we'll give you the secret Crime Talk Batline call-in number, and we can have a conversation about anything that you would desire to discuss. So if you'd like to do that, go down in the information below, hit the Patreon link. Boom, you get a link every time we put up a Patreon show, and there we go. Let's ask one more question here. Scott, can defense attorneys get in trouble with the bar after the trial is over due to violations and admonishments? Yes. If the attorney does something unethical, the court's not going to stop the trial and start all over again and declare a mistrial. They'll wait till the end, and they're like, oh, by the way, we've gone ahead and filed a complaint with the local bar. Oh, and Mr. Jackson and I think Alessi, I think only one is actually licensed in Massachusetts, the rest are pro hoc vice. So not only do you get a bar complaint where you allegedly did it, Massachusetts, you'd also get one at your state jurisdiction as well. Yeah, so that's going to be not fun if that happens. And, I mean, frankly, it's lawyering, ladies and gentlemen. People push the limits to zealously represent their client. Doesn't mean they've stepped over the ethical bounds. One could argue, oh my God, that question was objectionable. He knew that. That's a violation of the ethical code. No, it's not. It's lawyers lawyering. Okay. Like we talked about earlier, when somebody said, I can't believe the prosecutor's doing this and they're objecting. If they were all about the truth, they'd want it all to come in. No, we're in an adversarial system. If you think the prosecutor's going to do anything to help the defense out, I don't know where you studied civics, but that's not the case. It's an adversarial system. I don't care if it's a civil case or a criminal case. Each side is an advocate for their side. They don't have a duty to point out the bad facts to their side. They don't. Prosecutors are there to win. They have an ethical obligation. If they believe they can prove their case beyond a reasonable doubt, then they should go forward. If they don't think they can do that, then they should dismiss. Or someone who doesn't believe so many people would risk their careers for one to frame one particular person. I don't know. I mean, I've tried in the past the cops conspiracy thing. I think it's better when you just say the cop is a bad cop. Like I remember once I had a guy, simple routine traffic stop. He's videotaping everything. They're like, get out of the car. He's like, I didn't do anything. Next thing you know, there's a scuffle, boom, boom, boom. I didn't come up with a conspiracy. They're just bad cops, overzealous. They beat his ass because he was black. They didn't like it when he stood up for his rights and said, I don't have to do that. And it was a, machismo thing, whatever. Conspiracy of the cop stuff, it's so hard to prove unless you got a cop that's coming in to say, I did it with them. Let me tell you what I did. And this was the plan and this was the cover up. Not going to work. As you can see, I don't think it's worked this time. Kind of like the whole, well, they must have beat him on the inside of the house. Why? Because this ATF agent somehow got rejected or saw John O'Keefe kiss Karen at the bar. Therefore, he was enraged and wanted to kill him. Really? I guess there's some women out there that are worth killing for, but I'm not sure Karen Reed is that one. I just don't think she's the one. Just saying. All right. Time to go do our Patreon show. If you'd like to join us, go to the little link below, sign up. You can join us. Remember, we have the call-in number. And of course, at the end of the night, we'll figure out a question to ask the Magic 8 Ball. It could be like, will Karen Reed be acquitted in the case this week? And then you have to look and see what the Magic 8 Ball says. And, I guess you'll have to become a Patreon member to see what the Magic 8 Ball says. All right. That's all we have for you tonight. Thanks for joining us, ladies and gentlemen. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. And remember, the Constitution matters.
All right, lawyer.